Hello, everybody. Welcome to the Foreign Press Association of New York and our seminar, webinar, press conference on the possible changes and pitfalls of immigration status for journalists. We have a variety of people on the we have a variety of members. Some have become citizens, some were citizens and are correspondents for foreign publications. Some are on other immigrant visas. Most are on I visas. Some become, as I myself did after a while, an alien of extraordinary abilities. I followed the Robin Williams nano route. Uh, and these are all different ways that people have wanted to report on the US because there's always a worry, even with the I visa, there always has been. Because as I think we're seeing now is very often it's not what the law says, it's the fact that the prejudices, whoever is on the desk at immigration, have a lot to say. So you can't rely on the letter of the law, which I think will appear in the disquisition of our guests. Margaret Thatcher complained to Ronald Reagan that self-professed Irish American immigration officers in New York were giving the British a hard time. It took a presidential intervention. Nowadays, of course, the presidential invitation goes the other way. You know, they're foreign. Keep them out if you can. Um, so we should go ahead. We haven't got much time, but we have a lot of questions and to consider. The first is the general question of the status of the visas and what protections you've got. And a very effective campaign, I think it's from the Committee to Protect Journalists and from several other groups, basically advising people to shut up when they come in and not to presume that the people interviewing them are of goodwill and want to see them in to cover the United States. We have a dual jeopardy. One were foreigners, two were journalists, and neither of these seem to be on the gold star list for this current administration. So we have Olivia McLaren from the practice. She will introduce herself in full details to get the PSA for her practice, and Lenni from the New York from the NYU chair of
New York Law School.
yes of immigration. It was a big portfolio you had, but you're specializing in human rights and immigration. The two aren't necessarily oxymoronic, although it would appear to be at the moment in practice to discuss all of these. So if you go right ahead, the questions, I should say that both of our guests regret that they can't answer particular private questions for legal reasons, obviously, and also humanitarian reasons. They don't want to give wrong advice over a screen that could end up with you being hauled off to possibly Guantanamo or El Salvador or Libya or wherever is the current destination du jour for vindictive immigration officers. So if we can kick off, I believe it was Olivia, wasn't it? You wanted to.
I'm first.
You're,
I'm going to
you're
jump right in
Lenni,
if that's all
Lenni
right,
first.
Ian.
Sorry, and we're considering both the overall
Yeah.
principles of this and the particular applications and do's and don'ts. Mostly don'ts, I think. There's very little you can do in the face of a determined person dressed in a little brief authority with all of the prejudices of the MAGA behind them. So please kick off, Lenni.
Okay, so hi, I'm Lenni Benson, and I am at New York Law School, which is distinct from NYU. I think NYU gets a lot of credit for the faculty at New York Law School too. We have been around for 140 years, and I teach immigration law. But before I became a professor of immigration law, I was also a practicing business attorney, rather like Olivia. And so I represented large businesses, entrepreneurs, journalists, universities, and I have tried very hard to stay current. So hopefully my remarks will only that you have. But I do also want to say that I am always open to inquiries from journalists for background for the stories you're writing, for sources. Because I've been in the field since 1983, something that I often do for journalists is put out a query to the private bar or to nonprofit organizations to try to find sources for the stories you're reporting. So if you are covering immigration law writ large, I'm very happy to be one of your facilitators of finding the
Well, if you're
firsthand
happy
source.
with it, we'll post your contact details.
Yes, I will.
Thank you.
Second, I want to do that disclaimer one more time. I am an attorney, but I am not here to provide you with specific legal advice, and I will touch upon some of the questions that you have. Everyone's situation is so specific, as Ian just said a moment ago. We could do harm by recommending a particular course of action if we don't know all your facts and circumstances. All right, so let's get into some of the basics. And again, I hope that this is not totally new to you, but useful for you to reframe your thinking. The United States has always had what's called a dual check system since we began to have consular officers abroad putting visa stamps in passports. And of course, visa stamps today can be an electronic registration that you do with our Customs and Border Protection, a division of the Department of Homeland Security. You don't see a consulate at all. So some journalists do enter the United States on what we call visa waiver. There's approximately 40 countries. Some are new, some have had their permission revoked. And that particular entry to the United States is a pre-vetting by Customs and Border Protection, where you don't go to a consulate at all, but it's a very limited admission. You have waived all your rights. You have no rights whatsoever to contest the officer at the border. You have no right to a deportation hearing. The only thing you can do if you're refused on an ESTA at the border itself is to potentially seek asylum. Other than that, ESTA, the electronic registration process, if you read the fine print, you've waived everything. Now, why would that ever be appropriate for a journalist? Well, one of the things you can do on ESTA, and I think Olivia may touch on this more, is you can be a business visitor. So if you have colleagues that are not going to be stationed in the United States, but are coming in on a trip that's very brief, like to report on an event, the B1 or business visitor option is part of ESTA. So Olivia may talk about that more. I just want you to be aware, if you know anyone traveling on ESTA, they should read the fine print. Everything that you do there, you are waiving all your rights. Second, dual check system. You apply for a consulate, you apply at the consulate for an I visa or some other non-immigrant visa. And that is a stamp put into your passport by the US consulate. The State Department officers are exempt from judicial review. They cannot even be overturned by their ambassador. There is no hierarchy of command. Your very junior State Department officer is a rogue. They are independent. And Congress did that deliberately to avoid some political pressure put on consular officers. 90% of the time for Europeans and some people from developed nations in the Eastern Hemisphere, there's no issue whatsoever. Now, that doesn't mean that a refused visa application can't be addressed by an attorney or by your institution that's employing you, but it's usually a delicate negotiation and request for reconsideration rather than a fierce, I'm going to sue you, because the courts, unfortunately, by and large, there's a rare exception here or there, have rejected any review of an overseas determination. But let's say you're successful getting that particular appropriate visa stamp in your passport. When you present your passport and your visa stamp at the US port of entry, now that could be pre-flight inspection in Shannon, Ireland, or in Pearson, Canada, or it could be arriving at a port of entry like JFK. There you are now coming into contact with Customs and Border Protection. They're not Border Patrol, that's a division within Customs and Border Protection. They're supposed to be slightly better trained. They do have a chain of command. So there are officers on the front line, there are supervisors, there are legal counsel behind them. And so, if you do have an encounter with a border officer who is questioning the validity of your documents or putting you into what's called secondary inspection for further interviewing, you are likely going to encounter someone who's more experienced in doing an interview. So, why would a journalist or a business visitor traveler be put into secondary inspection? Uh, it can be for no reason at all. It can be actually also just for training. But the government, you should not be fooled into thinking that having a visa stamp means you cannot be put into secondary inspection. It is as powerful for Customs and Border Patrol to re-adjudicate, in a sense, or re-evaluate. Are you in the right category? So, for example, a moment ago, I said you might use ESTA to come on a reporting trip. That officer might say, nope, I think you're really going to be based in the United States. You're going to stay more than 90 days. This is an inappropriate use, and just reject you. Hopefully they reject you, allowing you to withdraw your application for admission. There's a regulation. I'm going to just cite it for the record. It's Volume 8 of the Code of Federal Regulations 235.4 that says the foreign national can request to withdraw their application for admission. Then there's no permanent bar to returning to the United States, and there's no temporal bar. If you are refused on ESTA at the border, they can make it an order of removal, and that's a 5-year bar. And then you would need waivers and lawyers to negotiate a special exception to that 5-year bar. An I visa, you're presenting yourself at the border, you're pulled over for secondary. What are they looking for? Well, we know from some reporting by journalists and from blogging from journalists themselves that certainly if you are of Palestinian descent, you could be an American citizen, you could be a German national, you could be a dual national with Britain, you could be someone who has been reporting on Palestine. You could be reporting on the war with Ukraine and Russia. You could be reporting on US tariff policy. You could just be someone they want to question. Why would they be pulling you out? Well, they get a plane manifest before you even arrive. They have all your names. They do run all names through an international database to see if you have ever been arrested or if there's any outstanding warrants. But they also sometimes have time on their hands. And so they'll run through. And if they see you are entering on an I visa, they know you're a journalist. They may pull your stories. They have Google as well as we do. And they pull your stories, and there's something in your stories that they think is adverse to US political interests. Yes, they will potentially question you further. We know in the first Trump administration that was fairly common, where Customs and Border Protection officers took it upon themselves to tell you that you were wrong about the reporting you were doing on the government. So happens in that secondary. First, the first advice that we had, and we have shared some documents with the Foreign Press Association about digital security. That the best advice is really that you're traveling with an empty phone, a phone that's been completely reset. Journalistic sources are not necessarily protected. Second, you need your laptop for work, but it should have everything up in a cloud and be closed and no automatic logins on anything that you're using. So if they do take your devices, which they have the right to do because your constitutional rights to privacy are almost none at it, unless you are a US permanent resident or citizen. That doesn't mean you don't have a property interest in your devices. And so if they seize your devices, they can forensically investigate them, and they should give you a receipt. You can refuse to give your devices, but my suspicion is if you refuse as someone entering with a temporary visa, they will consider that to be non-compliance with their legitimate inquiry to make sure you're consistent with the visa you're using. And they could either refuse your admission, tell you to withdraw your application for admission, or worst case, say, even though you have this visa, I don't think what you're doing is consistent with that visa. Therefore, you are inadmissible as someone lacking a visa. Or they may say, we believe you committed a misrepresentation or fraud to secure this I visa or this other temporary visa. And then they have the power under Section 235B of the immigration law to put you in something called expedited removal. So that's all the worst case scenarios, expedited removal. Again, the only relief from expedited removal, you would say, well, surely I get to see a judge and argue that I'm an appropriate journalist, I'm appropriate in my visa. No, you do not. You only get to talk to a supervisor. It only takes 2 signatures of an officer, of a CBP inspector, and a supervisor to expeditedly remove you. That's a 5-year ban. And in the last few months, I've been contacted by people who were digital nomads. So they were working for an overseas entity on a vacation in the United States. That overseas entity was owned by a US entity. CBP at Houston said that's illegal work in the United States. The person argued with them. They say, I'm canceling your visa. They cancel through it. They expeditedly remove that person. He cannot return for 5 years unless he secures a special waiver. So we need to take their power and authority into our dealing with them. And so consequently, some advice you're given when you are dealing with CBP is to answer the questions when you're in secondary, and then to, at the conclusion of the interview, say, am I free to go? Am I going to be admitted? And if they say, yes, I just need to finish this paperwork, you know that they've documented that interview with you and they're going to admit you. If they say no, you are being detained, then you should stop speaking. You have a choice not to speak at all, even in the beginning, but of course, in the beginning, you want to enter with your legitimate visa. But once they tell you you are being detained, you should stop speaking. Now, you would say, I would like to speak to an attorney, and they will tell you you have no right to counsel at the border. This is a constitutionally free zone. And so, again, I would urge you not to speak. You would think, but I can explain. Well, you can, but also every statement you use, they may use in a twisted way against you. So what if you are detained at the airport? If they're going to expeditiously remove you, it's usually a matter of 12 to 24 hours. They may take you to a hotel. If they want to detain you and punish you, uh, and put you into immigration detention, they can. The Supreme Court has not ruled that there is a right to bond or a right to be free from detention when you're an arriving alien. So some of the stories you've seen of students returning or workers returning, and they end up in detention, people who thought they were tourists and are coming back in and they end up for days or weeks in detention. CBP, unfortunately, does have that authority. You cannot mandate that they release you immediately. So you are taking a risk if they choose to detain you. Once you are in detention, you can ask to talk to an attorney because you're no longer physically just at a border. And that attorney can explain to you whether or not she or he will be able to do anything to get you released earlier. Again, there are options. One can try to negotiate with the government to just withdraw your application for admission, not be subject to that expedited order. The only exception to expedited removal is for returning lawful permanent residents, for people who've already been granted asylum, for people who are US citizens, for people who are entering as a refugee. Those people have a right to an immediate habeas in federal court if necessary. Usually it doesn't come to that. But if you are on a non-immigrant visa, you can be subject to expedited removal. And you may be saying, I've never heard of this. That's because it's not reported. They don't publish the statistics. And the last FOIA that I was able to get access to, that the American immigration lawyers did, 25% of all removal orders are expedited removal orders, because that's also a process that can be used at the land border within 100 miles of an international border. So in Buffalo, New York, Seattle, Washington, El Paso, Texas, Tucson, Arizona, it's usually foreign nationals from Latin American countries who are no documents, but it could also be someone who is with a document. So if you're reporting and traveling within the 100-mile international border zone, you should understand if you've been here less than 2 years, they can stop you. They can say you have the wrong visa. They can cancel that visa and they can try to put you in expedited removal. Let's hope that doesn't happen. And if it does, let's raise the roof with noise. Unfortunately, in 2020, the Supreme Court, in a case involving a man from Sri Lanka who didn't have any documents, who voluntarily surrendered himself as he crossed the Rio Grande River in Texas and said, I need to seek protection, and had very bad English. He was not successful in his brief interview with an asylum officer. He was not successful with the limited immigration judge review of the denied asylum credible fear claim. And the Supreme Court said that's all he's entitled to, that there's no need for more robust inquiry because that's all Congress has given us. All right, so again, let me summarize in general. If you are traveling with a non-immigrant visa, you're not a permanent resident, you're not a citizen, you're not an asylee already, granted asylum in the United States, or someone who's been admitted as a refugee, you have very limited rights at the border, and the power of CBP is tremendous. Now let's talk about the difference. You're successful, you get through the border, and you're issued an arrival document. That's called the I-94. The admission document used to be a little piece of cardboard. That's what Ian and I remember. You'd fill it out on the airplane, and then the officer would scribble in it. Sometimes you could barely read the date you were admitted to. And you're saying, but my visa is good for 5 years, or my visa is good for multiple entries for 4 years. Some countries, it's one entry, one time. Some countries, it's multiple entries over many years. That's based on reciprocity between one country and another. That admission document is no longer a card, it's now an electronic record. And attorneys will tell you in their emails that you need to log on to the Customs and Border Protection website and you need to look for your I-94 record. Everyone should do that the first day they're back in the country. They make a lot of mistakes, and those can be corrected. People like Olivia do correct them with their clients. The client says, I was admitted as a tourist, but I'm really a journalist. They know how to get that corrected with the port director. But that port officer, that Customs and Border Protection officer, even though you think I should be admitted for a year at a time, they may say, no, I'm only going to give you 6 months this time. And they can do that. And then you will need to apply for an extension of status in the United States. So that I-94 record for you and your family and your entourage is really important. And it's not what the officer says, it's not what your visa stamp says. It's what they put into that database at the airport or at the cruise ship or at the land port of entry in a car. All right. I think I've given you a lot about visa and status and how limited your rights are. One more topic inside the United States. If you've been here more than 2 years, you are not subject to expedited removal. You can only be put into regular removal. In this situation, if you come into encounter with an ICE officer, Immigration and Customs Enforcement, or with a USCIS officer, such as you're at an adjustment of status interview, you're trying to go from temporary visa to permanent visa, there you have rights to counsel. And if you have any concerns at all, and actually I advise this, if I were doing this myself, I would have an attorney. I would not try to navigate the adjustment of status from temporary visa to permanent visa in the United States without counsel. But let's say you're driving in California and you're stopped at a routine border checkpoint and the officer is questioning you extensively. There you have the right to say, am I being detained? And if the officer says, well, I have some questions I want to ask you, you say, am I being detained? And if they say no, you're free to move on. If they say, well, you're a foreign national, we have more questions for you. How do they know you're a foreign national? What did you say? What did you give them? This was your choice when you're in the interior to give them documents. If you did give them documents and they see you're a foreign national, they can ask you more questions about whether you're maintaining your status. You may say, it's no big deal. I'm just going to answer. I can show my last paycheck. I'm being paid by the BBC and I'm reporting here in the United States. That's fine, but you are starting a conversation where you are waiving your right to remain silent. Everything you say can be used. And you may think there's nothing wrong in what you say, but for example, I knew someone on an I visa that also had a real estate business and was selling real estate, had a license to sell real estate, didn't have another non-immigrant visa that authorized him to do that. That person was put into deportation proceedings because that work was outside the scope of his journalist visa. Your child is here on an I derivative visa with you and is babysitting. That's work without permission. The law can be incredibly harsh. Did I tell you how harsh it can be in the 1960s? They deported nuns who were staying and making soup because they didn't have the right religious worker visa. They had entered as tourists. So my general advice is when you're in the interior and you're not within the 100 miles of the international border of Canada or Mexico, you should not be answering a lot of questions unless you understand that answering those questions, anything you say can be used against you. And yes, you can be arrested. And yes, you can be detained. And then good thing is you're put into regular removal and you have more rights. There, the government would have to say that you are removable and the burden would be on them. But as you may have seen in recent days, they're arresting people even with green cards, and they're trying to use political activity to argue that your presence in the United States is contrary to the interests of the U.S. government. That is found in INA 237A4. It's a very broad category. It's rarely used. Most of the time so far, the government has not succeeded. People are being very aggressive in saying there's no evidence of this person being a danger to the United States, and the government is not being prepared. They've sort of leapt before they were ready to run. And so I can't really advise what would happen in the future, but some of you are going to say, but the First Amendment, I have complete protections under the First Amendment. Well, I believe you do, but I'm a law professor who is on the left. On the far left, so far left that I almost be on the right. Like the right and the left here come together. We believe in libertarian speech, right? Um, the Supreme Court case law is not clear. For US citizens, First Amendment protections are more robust. But for foreign nationals in the 1960s, they lost a lot of cases. They were members of the Communist Party, they held from the party, they could not become citizens, and they argued that they had the right of association and the right of speech, and they lost. Those precedents still are on the books. They're shaky, but they're there. And so if you want to be the guinea pig to help us establish First Amendment rights for foreign nationals in the country, I'll help find the law professors that write the brief in your support. But I cannot assure you that you can have a mantle of First Amendment for the tremendous authority that DHS has to find something wrong with your technical compliance with your non-immigrant status, and then to argue you're deportable, not for political reasons. You're deportable because you failed to maintain your non-immigrant status. And there's so many ways to violate that status, that in inadvertent ways, that they may be able to do that. And then it will fall back on you to try to find some kind of relief. And the relief may be saying, I'm ready to leave the country. All right, Olivia, I've set it up, given you a lot. I'm sure you can take it away and make it more granular now.
I think we
Okay.
might have disturbed the sleep of many of our members.
Yeah.
Oh
I didn't know
gosh.
that the first 2 years on an I visa you were sort of on probation, and your status was, let's say, readjustable by the prejudices of whichever redneck was behind the desk. But it's luckily it doesn't apply to me anymore. But if both either of you could also address the question of whether the naturalized citizens have any of them have been revoked so far? Because it's happened in other countries, as in Britain, for example, where the government has capriciously decided that young girls who were trapped by ISIS are now have their citizenship revoked.
Yeah.
So
I
I'd like to throw that in because it applies to some journalists as well. If you write rude things and you're a naturalized citizen, who knows what happens?
I can
I
say
can
Now,
answer
that's
later
on
if
the
you want,
radar.
Linda.
That's, I'm not aware, and Lenny can answer as well. I'm not aware of any specific cases where denaturalization proceedings have been brought against someone by the current administration, but it's something that a lot of immigration lawyers are chatting about, whether it's
Yeah.
likely or
Why don't
possible.
I pick it up after you've done your comments? Because I do know of one
Yeah.
recent case in New York.
Okay. All right, and I wanted to mention in reference to the expedited removal issue, there's one strategy which I suggest to people who are visa holders to avoid that quagmire, which is to use pre-clearance facilities. Because, for example, if you travel through Dublin, Brussels, or any of the other worldwide pre-clearance facilities, and they refuse your entry, you are not subject to expedited removal proceedings. And so while you may be refused, your visa may be canceled, you won't be subject to a 5-year ban on obtaining a new visa. So, on the flip side, sometimes the pre-clearance facilities have a lot of time on their hands. So I'd say there's certain periods where I feel like I have more problems coming out of pre-clearance facilities. So, it can go both directions, but it is
So this is
worth
bored
noting.
immigration, bored and restless immigration officers can exercise their prejudices when they have time.
Yeah, if they have too much time, then that's not helpful.
Dressed in
But
a little
but
brief
the
authority,
outcome,
Shakespeare had it.
that's right. The outcome, if they refuse the visa, is if they refuse admission, is more favorable. So I'll move on. I was going to talk a little bit about I-visas for information media representatives, how the parameters for that visa are shifting, if they are, and what alternatives may exist. So I'll try to be quick about it. So probably many of you, if not all, are aware that the I-visa is available to information media representatives, including journalists, researchers, producers, presenters, on-air personnel, and people whose activities support information media function. And it's also for employees of independent production companies, some self-employed or freelance media, new media, and foreign government tourist bureaus. In any event, the activities of the I-visa holder must be about gathering journalistic information to disseminate overseas. So an I-visa can't be used for things like reality TV, or somebody who is, say, like a professional blogger, an influencer going to the United States to create content that's really about their own activities. And it can't be used to promote products. So as Lenni briefly mentioned, the length of the visa, in this case, the I-visa issued by the consular post, is based on reciprocity. So what does the applicant's home country allow for US journalists? So for the UK, for example, which is where I'm based, it's 60 months. For Haiti, it's 24 months. For the People's Republic of China, it's 12 months, and so on. So it just depends country by country. And as Lenni mentioned, some of them are limited to, one visit, and some are multiple entry. In terms of the landscape for obtaining an I-visa at a consular post, the likelihood of success for most I-visa applicants hasn't changed dramatically since the new administration has come in. The law hasn't changed, but as the State Department said to us in a recent liaison meeting, this is the year of the executive order. So they're looking for certain affiliations and sympathies, with a new focus on social media posts that are pro-Hamas, pro-Palestine, anti-Israel, or anti-Semitic. And that's not all, but that seems to be the main focus at the moment. For more information on those and what that means, you could have a look at Executive Order 14188, which is additional measures to combat anti-Semitism, and Executive Order 14161, which is protecting the United States from foreign terrorists and other national security and public safety threats. There are a number of legal challenges to these orders, but those are, for the most part, ongoing. In terms of stories on the ground, I heard a report from a colleague that their Palestinian I-visa applicant client was placed in administrative processing, and that usually entails additional security screenings, and it's kind of like a black hole. We can't get much information from the government about why someone's in this administrative processing or how long it's going to take. In this particular case, the lawyer doesn't hold out much hope that the applicant's going to be cleared for travel anytime soon. And I think that there's a lot of that happening across all visa categories, not just I visas. In terms of entry to the US and maintenance of status, there's been no change to the law, but there is pressure on all the federal agencies to look closely at people according to these executive orders. And for example, very recently, the DS-160 non-immigrant visa application, which you may be familiar with if you've applied for a non-immigrant visa in the past, it now has to be submitted more than 2 business days in advance of the interview. And if you didn't submit it early enough, they'll turn you away at the door. And that's so that the State Department has time to vet the applicant's social media history. So at least that's what we think is happening. And I think there's widespread concern that the administration is looking at people for being kind of like anti-Trump administration. And while there's a lot of evidence that there's retribution by the administration against various US organizations like law firms, I haven't heard reports, and Lenni may say differently, but I haven't heard any reports of someone being refused a visa because their online content was negative about the current administration specifically. So we'll see where that goes, but I just haven't seen it. So in other words, as far as I'm concerned, the main risk areas at the moment are what nationality or country is the applicant coming from? And do they have a public profile through work or social media activity that has content that the US government is focused on right now, like being pro-Palestine? And then I've also been asked to briefly mention some other visa options that are commonly used by journalists. Right now, I have a major media company who's using the L1 intracompany visa for international assignments. Although it's more expensive to obtain than the I visa, and I'd say a lot of non-immigrant visas, most if not all, are more expensive and more administratively burdensome than the I visa. But the L1 has the added advantage of allowing spouses on the dependent L2 to work. So that one is available to individuals who have at least 12 months of experience working for a company overseas in certain roles, managerial, executive, or specialized knowledge, and they're coming to the United States to work for a related entity in a similar managerial, executive, or specialized knowledge role. So that can be used for jobs or assignments that don't fit the I visa requirements. And similarly, for a while in Trump 1.0, we were seeing I visas refused for live sports broadcasters for a bit. So we started, I don't know if you remember that, Ian, because I think I may have emailed with you at the time. So we turned to the O1 for a large production company I was working with, and we got an O1 for the technical director based on his extraordinary ability, and O2s for his essential support personnel, so they could kind of travel like en masse. There's a big alphabet soup of visas, so these are not the only 2 options. There's the H-1B, the E-2 for investors. The visitor visa or ESTA could be appropriate in some really limited circumstances, like if you're going to a meeting, and it really is quite narrowly prescribed, but it does work in some cases, and others, which I won't bore you with because they're less likely to be relevant. So that's it for me. I'm going to stop talking now in case
I'd like to ask
questions.
both of you, because there's an issue. Many of our members also are accredited at the United Nations. I was a former
Mhm.
president of the UN Correspondents Association. And the
Sure.
assumption when I was there more actively was that the headquarters agreement between the UN and the United States allowed some sort of additional protection for journalists accredited to the United Nations because their status was implied as covered by the headquarters agreement, which I believe allows access to the foreign press to come to come to cover the United Nations. Are you aware of that? Has there been any change, or is there any reinforcement, or was I just living in a thin blue cloud cuckoo land at the time?
I'm not aware of any change. And of course, this administration is not clearly in support of everything the UN does. So I don't know that I would put all my hopes into that protection as well. You know, we don't mean to scare everyone completely. I saw in the Q&A, someone said, oh, so they're harassing journalists as they are students. Students are incredibly much more vulnerable because they've used an electronic database where they tried ineffectively to revoke the status of over 4,600 students while they were in the United States based on any kind of fingerprint hit in the federal system. So anytime someone is getting fingerprinted for a security clearance or fingerprinted for an arrest, that ends up in that database. So some of the people that initially lost their student status had no criminal activity. The foreign students, of course, is they're looking at the records the school has put into the electronic database called SEVIS or SEVIS, SEVIS, in which if a student's been suspended from school, there's a little checkbox. I think that's outside the regulations. That being suspended doesn't mean you're not still going to be allowed to attend the institution, but termination or expulsion from school is a reportable event to ICE. ICE runs a SEVIS database, and that all came about after 9/11. So certainly the presidency's administration wanted to make a big splash, and they have made a splash by targeting students, as we know, who they claim are involved in political activity opposed to the U.S. foreign affairs. Now, primarily, they're not being very successful in court so far on some of those cases. Some of the lawyers that have litigated the student revocation of status have won on technical grounds that the government just didn't dot their I's and cross their T's, and those students were then quickly reinstated. Now they're seeing revocations again, and that is an area that's really, unless we're talking about foreign press journalists who are also in student status does sometimes contain the ability to work on campus or to work with permission after graduation, but it is a vulnerable category because they're targeting it. I wanted to go back to denaturalization for some of your members who may have become US citizens. In both the first Trump administration and then the Biden administration, they stood up a team of US attorneys working together with the team inside of DHS to identify people who may have fraudulently obtained their permanent residence. And they focused on people who were able to obtain asylum by attorneys that they had also identified as putting in identical claims for hundreds, if not thousands of people. These involved people primarily from Romania, Albania, and the People's Republic of China. And there are lots of people that have had naturalization and permanent residence for years who are now finding themselves in trouble because they targeted their lawyers first. So sometimes in immigration law, people think, oh, I'll just go this route or that route. It's easier. And obviously, I always say to my students who are a small white lie today can unwind everything later. But last November, in a shocking case, the government succeeded in denaturalizing a man who is from Pakistan. And the way that they did it was he was criminally convicted of providing a cell phone to someone who used his phone to transfer funds in support of an alleged terrorist organization. So by giving his cell phone to a person who then used it to make a wire transfer, and their tracking of that transfer was it went in support of Hezbollah, they were able to convict him in federal court. And that activity, the use of the phone, took place before his naturalization. So what the argument in the denaturalization was, you were not honest in your naturalization forms. And one of the absolutely horrific questions in the form, this is the N400 form, is, have you ever committed a crime for which you've not been convicted? And I always say there's not a person on earth.
We're all sinners.
Yeah, I mean, maybe a 3-year-old who has not committed a crime for which they've not been convicted. My mother used to always taste the grapes in the grocery store. That's theft. Until recently, jaywalking in New York was a criminal activity. It has been decriminalized. Definitely jaywalk before it was decriminalized. Let us not even go into the use of cannabis, which is still a federal offense, and no foreign national should
Which the
use
Beatles were
cannabis
caught on, of
anywhere
course,
ever.
famously.
I am serious about that. You don't believe me. I'm serious.
No, the Beatles, remember John Lennon was refused a
Yeah,
visa
well, that was
initially.
actually hashish, and that was actually because of his political activity.
Yeah.
But they brought in the law after they lost the case against John Lennon to say any conviction relating to a controlled substance necessarily need to be convicted. Remember, the naturalization form says, have you committed a crime for which you've not been convicted? So do people answer that truthfully? No, most people answer it. They don't think deeply about it and they just go, no, I've never committed a crime. Well, if you wrote no and later you admit you used cannabis, that's a federal crime. That could be a basis of denaturalization. So you see how
As
any
long as you didn't inhale.
conversation, no possession is still a crime.
Yes, I know.
Sorry.
I'm being
Yeah.
That's
facetious, of
President
course.
Clinton trying to be clever, but and I believe he was in England at the time on his fellowship at Oxford. But the point is that journalists are good at asking questions and learning information, dark side of everything. And so if we frightened you today, or we said it could be really bad, yes, it could be really bad. Is it, sorry, my internet just went low. Is it bad in general? No. But should you be thoughtful? Yes. So, Olivia, what other questions do we want to answer here? I think there are some general questions about, should people rush to adjust status now? And how does that affect their families? Maybe we could just talk about that.
Yeah, I mean, in general principle, I mean, how much more protection, I mean, if you're a permanent resident, do you have from some of these things? Maybe a little bit, but
Or at the border for
ultimately,
sure. You can't be
yeah,
put in expedited removal.
yeah. So I mean, and yes, but it's not a fail-safe.
That's right.
It's not going to protect you from every conceivable problem that could come up in U.S. immigration. And there are tax implications to becoming a permanent resident. So have a look at those first as well.
And
Let's
if you
see.
do have family members that are going to age out, in other words, turn 21 or become married, they cannot have a derivative status unless you do secure a permanent residence or they qualify for in their own. And the vast categories, like Olivia and I usually say, I don't know how you do it, Olivia. Someone says, how do I get a green card? And I say, how do you fly to Chicago? How do you get to Chicago? You can fly, you can walk, you can take a train, you can rent a car, you can hop a freighter. There's so many ways to adjust to permanent resident, and each one of them has their own obstacle course and their own lengthy process. And so preserving access for your minor children to obtain long-term residence in the United States is something you need an individual consultation about.
That's right. And I mean, you're dealing when somebody's getting close to aging out, a lawyer really needs to sit down and look at the framework for the Child Status Protection Act as well. So it's more complicated than simply filing. It depends on what you're filing, what kind of, underlying petition is involved, and how the Child Status Protection Act would apply as to whether they
And
would
what
get any
country you're
benefit
from,
from it.
because
That
there are
too.
quota
Yeah,
delays now in some categories that were never delayed before. And
that's
so
right.
you may be at a cocktail party with someone who says, I got my green card in 3 months. Those were the good old days. Even marriage cases today, I believe, are taking 18 months of processing or longer.
Yeah,
So
if we do immigrant visa, it takes a solid 2 years, and that's the UK, which is one of the fastest places in processing. Some countries, it's taking like 4 years. It's pretty
that has nothing
bad.
to do with the Trump
So,
administration. That has to do with chronic underfunding.
mhm.
Another thing one should anticipate, I think, just given what we've seen in the liaison minutes, and you know this better than me, Olivia, because you attend those meetings, the State Department has announced a lot of reductions in force and a lot of retirements, and they are closing consular posts. So there's a consolidation. Not every country will have the ability to issue immigrant visas. I believe, for example, Brussels is closed and you have to go to Frankfurt, right, Olivia?
They've moved immigrant visa processing, and Edinburgh, the consulate in Edinburgh, which actually doesn't process visas, it just does American citizen services. But there's so many Americans in Scotland, it's shocking. Like, it's a very small country, and a big percentage of it is full of Americans. So we're trying to get them to keep that open. But there are lots of posts on the list for potential closure, Florence, and I can't think off the top of my head of the many that were there. I think there may have been another one in Italy. So that will definitely affect the processing of all sorts of benefits. And in terms of USCIS adjudications, it's interesting because most of USCIS operations are user funded. They're funded by the fees collected with the applications. So as far as I'm concerned, there's a lot less justification for closing them, for closing these offices, firing people for efficiency's sake. I don't know if you disagree or agree with that, Lenny, but it doesn't make a lot of sense to me
It doesn't make any
why there would
sense
be a
at all.
reduction in
The
force.
immigration court, they did a reduction in force of the judges, and they have 4 million pending cases.
Yeah.
And I just saw one of my former students who's a law clerk there. Of the 80 clerks that are in New York, 50 have been forced to leave. And the 30 that remain were not given the raises that they were promised. So many of them are looking to leave. So at a time when our government is saying they want to move more quickly, they're actually shrinking the resources of those agencies.
Okay.
So we have about 10 minutes left. Are there any questions we haven't addressed, Olivia, that are in our chat or?
There's a specific question, also wondering if you're seeing or anticipating delays in the length of time to get I-visas. So I would say right this minute, the processing times are better than they were 3 years ago because we've rebounded from COVID. But I think if you're looking forward, processing times, the wait to get a visa appointment in any post around the world is only going to get longer because they are reducing staff and spreading themselves thinner. So I just don't see how it could improve on the same thing.
Olivia, could you talk about Section 214B and why that gets written sometimes in a passport?
So in terms of Section 214B, that's a provision of the INA, the Immigration and Nationality Act, that says that, it says more than one thing, but the gist of it is that anyone who applies for a non-immigrant visa, and there are a few exceptions, but in general is subject to a presumption that they're an intending immigrant to the United States, and the burden is on them to prove otherwise, right? So when you apply for a non-immigrant visa, you have a negative presumption against you most of the time, exceptions notwithstanding. And you have to overcome that through the way that you answer questions on the DS-160 form and the way you're prepared to answer questions before the consular officer. They tell you to bring some other ancillary documentation. You bring bank statements, you bring evidence you own a home, but the consular officers are trained generally not to look at that stuff. So it's frustrating because you'll prepare a giant packet of documents for a client to take to the interview. The consular officer will push them away. I don't want to see any of that. So anyway, that is all about this 214B. And it gets complicated because sometimes consular officers in particular will use this section of law to refuse visas. And it another thing I should actually, just to backtrack, another use of the 214B is when they say you're not applying for the correct visa category.
Right.
So
Can we have Eva Schweitzer, one of our German members, asking a question. Eva, can you get on and tell us,
Yeah,
ask a question?
Hi, can you hear me?
Yes.
Yes.
Oh, good. Okay, thanks. You mentioned somewhat earlier that if you're in the United States on an I visa, you are not allowed to work for an American media because that's considered illegal working. That's correct, is it?
That's correct. You're meant to be working for foreign
Foreign.
media when you're in the
Okay.
United
So
States
what-
on an I visa.
So what is if you are in your home country and you're working for American media? Is that possible? And second question, can the newspaper you are working for sell your stories to an American media? Like syndicate them?
If you're overseas,
Mhm.
you can work for a US company
Okay.
if you are compensated in your home country.
So what is if I'm
Certainly,
going
there-
back and forth? So like I'm in June, I'm in my home country. So can I work for American paper in June, or does it not work this way?
So again, we don't have a digital nomad visa. We don't have a general come in as a tourist and work for a US company, and there's an idea that you can come to a business meeting. You can come to a conference, but if you're actually doing reporting in the US for an American media company and you're using a tourist visa or an I visa, that's the wrong visa. Olivia, do you
No, if I'm
disagree?
doing reporting for an American paper while I am in Germany,
Right.
is that
So
possible or not?
yes, in Germany, but not in the
You know,
US.
what if I'm going back and forth every month? So not if I'm permanently in Germany, but I'm still in the United States. So kind of like in between work for an American paper.
Ava, I think one clarifying point is that visas are only relevant to when all of this is really only relevant to when you're physically in the United States. So if you're anywhere else outside the United States, it doesn't matter who you work for when we're talking about US visas. But if you're going to enter the US and do work in the US, in order to use the I visa to do that, you have to be working on behalf of foreign media. Now, if you're working for a company overseas, foreign media, and they do disseminate to an audience outside the United States, and then something totally separate is happening with the because I mean, we live in the internet age, right? Things move around, they go different places. So I suppose it's about a matter of degrees, right? But if you're working for an American company, an American media company in the United States, the I visa does not work for that at all. So
No,
as
I
in,
know. Yeah.
yeah.
I have
So if you're
personal
moving
experience
further
of this,
away, like degrees, then you probably want to take advice about that to make sure
And you can
that
have
you are using
multiple,
the right visa.
you can have multiple non-immigrant visas. So
Yeah.
it might be you need an H-1B or an O-1 for your US work and your I visa if you're working for Der Spiegel.
Yeah.
in
So, but
years past,
let's say I'm working for Die Spiegel. I don't, but let's assume I'm doing a story for Die Spiegel or an interview with Ian for Die Spiegel. And then the Spiegel sells my interview to the New York Times. Is
That's
that
fine.
legal?
That's fine.
That's possible.
Yeah. I mean, the rules are so arcane sometimes. If you are a writer and you rent an apartment in New York and you write your novel, that's fine. But if you sell your novel in the United States while you're here, you've just worked illegally. Same with painters, same with potters. The arts are complicated, right? And of course, people have done this and never gotten caught. But as Olivia just said, we live in an internet age. So if you're regularly posting to your readers, I'm writing my novel in the West Village, and it's great because it's infusing all my thoughts. And I'm so glad I have a meeting with Simon and Schuster tomorrow. And oh, I sold my novel. You just admitted that you were working without permission.
Okay, I see. Yeah.
And we've got another question that's just popped up from Georgie about being able to run a personal YouTube channel unrelated to news alongside work for a foreign news organization. So I'd probably need to know a little bit more about this YouTube channel. If it's entirely an amateur endeavor for fun, it's not, you know, accepting sponsorships or promotions or earning any money, then it may be something that's acceptable. But I think if it's a commercial endeavor, then it would potentially constitute a violation of visa status. So
Olivia, if it was a YouTube channel based abroad, you know, with a YouTube network abroad, I thought in the Foreign Affairs Manual I saw something that recognized that. But again, this is all technical. Like, where's your revenue stream going? Which bank account is YouTube paying you? Where do you say when it says in that about, you know, are you saying you're based in Kansas City, or are you saying you're based in Paris?
yeah, and I mean, where are you gathering the content? Does that count? I mean, so it's probably a question of more information is needed to
I
give
agree.
an answer to whether that's
Or maybe less
acceptable or a
information is needed in
violation.
case you're leaving hostages to fortune there. You know?
Yeah.
So it's after 11 and I apologize that I need to depart soon
Yes,
because today is graduation for New York Law School and I'm obligated to get across town. Is there anything else you need me for today? Maybe Olivia can stay
I
on a
think
little.
we should be winding up now. I just wanted to add that this is not just a Trump administration thing. When I was reporting from the United Nations and Madeleine Albright didn't like what I was writing, she called up the Foreign Press Center at the UN to see if I was entitled to be writing for American publications. Luckily, I'd transited by then from an I visa, but it shows, you know, there's a general political malice around. So you have to watch out for the caprice of those in power, as I said, dressed in little brief authority. But we're going to monitor this, and we and the Foreign Press Association are looking, and we hope that Olivia and Lenni will alert us to any forthcoming changes, because we did successfully thwart it last time when they tried to change the I visa's qualifications. I'm not sure it'd be as successful this time because this administration does not seem to have a shame button we can push, but we will try. So please, everybody, if you hear of anything, keep us alert and let us know because we can help publicize a case. And as we have seen recently, uh, journalists get locked up in the dark. It's our job to bring light to it all and to make sure that this is that they don't get away with this. Even if they do commit
So
crimes, we have to show it in public. And but you have
I
to
hope the
allow for
Foreign Press
caprice.
Association will share the resources that I gave you and my contact information at New York Law School. I'm happy to have you email me. My phone number is in my email signature as well. I'm happy to talk on WhatsApp. And I also gave the Foreign Press Association a link to a press freedom tracker where they're asking journalists to report on problems. Doesn't seem to be very active lately, but it could be that people are not reporting.
We shall make it so, as they say.
Okay.
I have to
Thank you, Olivia, for inviting me as well. And I really am sorry that I have to go. Graduation is a time certain and I've got to get there.
thank you for the the disambiguation, as they say on Google, between New York Law School and NYU, which has been pretty shameful in these issues lately. Um, in
Bye-bye.
All right, bye, Lenni.
Okay, goodbye, everybody. We will be coming back. We have more seminars coming up, and do keep in touch. Do join the Foreign Press Center if you can. Do, by the way, donate to our work because we're running on empty. We've had so many demands lately. Any philanthropic benefactors you know, tell them where we live so they can send a check. Thank you very much, everybody, particularly the two of you for a very detailed and how should we say foresightful investigation of the issues, not just the issues but anticipated issues. So once again, thank you very much from the Foreign Press Association, and do come again soon. Bye, everybody.